Hey, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted. Glad to be with you here this Wednesday, December 14th. I'm not going to screw that up. And it looks like we got video this time. So, hey, we're one up on last week's big show. Again, so this, live from the fortified compound here in Mesa, Arizona. We're here live. We're going to do what we can to be live every Wednesday here on, it's right now on Ustream, but then we get it posted up my YouTube channel. It's No State Project, and we get it at markstevens.net, so you can check that out there also. If you want to join me on the big show for today, you may do so by dialing 218-632-9399, 218-632-9399. And Skype is, as usual, Frank Rizzo 3. That's Frank Rizzo with the number 3. Yes, it is a Jerky Boys reference, so it's easy to remember. Much easier to remember. I got a lot of stuff to get to, but we've got callers already. I know we've got people who wanted to call in. So what to do that is, without further ado, we've got area code 661. You're live on the No State Project. What's your name? Where you calling from?
Hey, Mark, it's Brad. I'm calling from Austin.
Brad from Austin. What do you have for us today?
Yeah. So I got a ticket before Thanksgiving, or, pulled me over. No question or no answers to the questions. They just handed me this paper, made me sign it. And they said I had to appear before a court in 20 business days or whatever. And it was Thanksgiving, so that was a while ago, but it was business days. So now I guess the deadline is this Friday. I appeared. I don't know what they mean, because when I walked into the court, the county clerk handed me a slip of paper, and she said, you have to sign this before you get your court date. And the thing that I had to sign was an admission or a plea of not guilty. And so, yeah, that's the first trap, right? So I said, no, thank you. Can I just have a court date to set the arraignment? She says, I don't know what you mean. You have to sign the paper. So I said, well, can I talk to the prosecutor then? She handed me the paper. I'm still waiting to hear back. But I've talked to their legal team, and they don't know. They said, well, there's a process you have to follow. Well, so I don't know. I'm at a loss exactly how to deal with them, because they're saying, well, we don't have any more court dates, so if you don't appear before the court, you're going to be in more trouble. So now I'm in, a catch-22 situation.
Well, did you get the motion to dismiss and the Brady request?
Well, see, I didn't file that stuff because I thought that you have to have, some sort of docket number or actually open case, and I've been trying to get a hold of them. So... yeah, those papers didn't land on their desk because I've been kind of in limbo. So, I don't know. And they're probably going to say, well, we don't have enough time. But...
well, the thing with the motion to dismiss is when someone files a motion to dismiss, that should be dealt with prior to the entering of a plea. So, we want to, even if you're going in there, like you did the other day, you should still go in with the motion to dismiss and the discovery request. So this way, because what they want to do is they want you to enter a plea. They don't want you challenging jurisdiction. They don't want you challenging the sufficiency of the complaint. They just want you to come in and traverse the merits, and they want you to discuss whether you are guilty or not guilty. And what they love to do is lie to you, because that's what they do best. Well, it's what they do second best. They hurt people. They're the best at hurting people and killing people. So they lie, saying that if you want to see the judge, you have to plea. And giving them the benefit of the doubt, in their minds, they may be thinking a hearing on the merits of the cop's complaint. So when we tell them, well, no, we don't want a hearing on the motion. I mean, a hearing on the merits of the complaint. We don't want a trial, but if you're going to set it for a hearing date so the prosecution can come in and we can discuss it in front of the judge, set it for a motion hearing, which is not a trial. And they may still, especially if you're in California, they may still want you to put up a bond in order to get a hearing on a demur.
I see.
So, they may try to pull something like that. And what I suggest doing is when they're pulling this crap that they want, that they have to have a bond in order to set it even for a demur hearing. You could tell me that, well, you know what, just have the judge make a ruling on that. If I need to get a hearing, I'll file in the higher court if the judge denies my demur. Or you can just ask them, well, look, you're acting under the assumption that the prosecution has submitted evidence of jurisdiction to even require me to pay a bond. Is that true? And well, of course the court has jurisdiction. Okay, since you're asserting this jurisdiction and you're the blowhard who's telling me that I have to pay this bail, this bond, can you tell me where in the record there's evidence proving your Constitution applies to me just because I'm physically in California or wherever the hell? Here in Texas. And the clerk may hem and haw and say, look, well, bottom line, so where we are here is I have a clerk who's not going to take my paperwork, who's not going to set it for a hearing, absolutely insisting that there's jurisdiction, but can't prove it. Why should I pay you any money whatsoever? Why should I do that when you can't prove this court has any jurisdiction over me to begin with? So what do you say to them? They say, well, if you don't want to pay, there'll be a default judgment against you and a warrant for your arrest.
Right.
What do you say to that?
That's why I'm calling in. I have no idea how to deal with these people. I have all the I've got a list of the questions, but I'm sure they have all these specially crafted witty things to say back to me, and there I am standing, sweaty palms and nervous because I don't want my life ruined by these people, but also principles, right? I don't know. What do you say?
Well, I've already told you, basically, you got to remember that everything that these people are saying is a lie. So it's really the same thing, just repeating what we've already said. You're insisting that there's jurisdiction to have me pay this bail, and that there's jurisdiction to to issue a warrant for my arrest. Once again, ma'am, given the fact you've just threatened me, do you have any evidence from the prosecution to back your assertion up that this court has jurisdiction to do that? So you're going to threaten me with a warrant even though there's no evidence in the file to prove jurisdiction to issue the warrant in the first place. At least you're getting something from them that you can then use against them. And say, look, I even spoke to the clerk. The clerk is making threats against me, and they admittedly don't have a shred of evidence from the prosecution.
Right.
So it sounds to me, Brad.
Go ahead.
It sounds to me like you need to do a lot of role-playing to prep for court, because when you say that they've got specially crafted responses or answers, see, that's the thing when they are just a gang of killers, thieves, and liars, men and women forcing us to pay them. They have no evidence. It doesn't matter how they craft a response to you. If there's no evidence, then whatever they're saying is not responsive. So there's nothing. Imagine this. Imagine going into court and going toe-to-toe with the Chief Justice of the Supreme Court. How do you think you would do? By asking, just by answering. Why?
Well, probably because most of the determinations of the justifiability of somebody's claim is whether or not somebody believes you, not whether or not you have evidence. And that's one of the frustrating things I've had in the journey of learning about anarchistic and voluntaristic philosophy, if you will, is that most people they're not persuaded by evidence, they're persuaded by emotion. And that's why supposedly we're supposed to have this majestic court where justice is blind and so forth.
Yep. So
I would imagine I would look like a terrible mess, but if I stuck to my guns and said, show me the evidence, then I suppose, in a fairy tale I would make them look like fools, but I don't think so. I think that they have the guns at the end of the day, right?
Yeah, but we're not talking about that. We're talking about just being able to engage with somebody who is a Chief Justice of the Supreme Court and get them to either verify their claim is true or bring out that they can't prove that it's true. So we're leaving the guns out of it. We know they've got the guns. I know that. But I have a video on my website where I went against the Chief Justice of the Arizona Supreme Court. And I did that at the ASU Law School in front of at least 100 lawyers. Well, let's say there were a lot of lawyers. It was a law school, for heaven's sakes. But I can't say for certain that everybody there was a lawyer or a law school student. The fact is, Scott Bales could run circles around me education-wise. But what he doesn't have is he doesn't have any evidence to support his claim that just because I'm physically in Arizona, his rules apply to me. Not a single fact to support that claim. And he didn't try to make the claim, well, no evidence is required because our rules are special. No, he went to an argumentum ad baculum, which is a basic logical fallacy, an appeal to the stick or an appeal to consequences. He even doubled down and agreed it was an argumentum ad baculum. He just argued that it was a non-fallacious version of it, which it wasn't. It clearly wasn't fallacious. So if you just understand with the Socratic method, you're just asking questions, and it's who, what, where, when, why, and how. It doesn't matter how fancy of an answer they spew out at you. Bottom line, you will be able to recognize they're not being responsive, and you'll be able to make an objection if you're actually in court, or you'll be able to just point out that's a logical fallacy, but do it in the form of a question, and you'll do very well. And it won't matter if you're talking to the lowest police judge or you're talking to the Arizona or the U.S. Supreme Court Chief Justice. It doesn't matter. What matters is the argument sound? And the arguments that they're making, hell no, they are not sound. So you don't have to worry. So you need to do the role playing.
Gotcha. I do have a solid question for you, though. Something that I'm not entirely sure about. I understand the whole process. Like I don't know how to, like, all the various nuances to it. But when they say, well, okay, well, you're physically there, so that's evidence, or something like that. Like, well, okay, what's your evidence? Well, we've already given you evidence. Why don't you accept it? Because I've gotten into arguments with my lawyer friends, my JD friends. You know, they've been to the law school or whatever, and they said, well, you know, this Mark Stevens guy, he's just never going to be satisfied with any answers. I've heard you echo people's responses like that too, but I'm still unsure. Like, what's the follow up to that? We've already given you the answer, but you just won't accept it, and we're going to go through with whatever we're going to go through with.
Well, you can ask them to clarify. You should maybe do that before. So if I'm asking a question of fact and you respond with a legal claim, is that responsive to the question? Well, no, it's not. Well, then don't be a douchebag and accuse me of not accepting your answer. You have to answer the damn question. What I say there when they say about, well, you're here physically, just ask who, what, where, when, why, and how. So you can just hit them with how. How does my physical location prove the Constitution applies to me? Keep it on them. I have prosecutors who have been doing it for decades on markstevens.net under the Call of Shames, where I have a prosecutor that in Washington that insisted the laws applied because the guy was physically in Washington. I said, well, how so? How does that prove it applies? It just does. And if they're going to say things like that and say, well, you're not going to accept an answer, well, then you're dealing with somebody who is so dishonest and so bought into the system, he's not willing to see where he's making a mistake. So you may want to just flip it around and do the same thing to them, like I mentioned. Do the same thing. Don't answer their question and say, I've already answered you. What? You won't accept my answer. And then say, you know what? That's exactly what you're doing to me. Answer the question. So it's just like Brad, someone the other day with a tax agency. Where's your proof that the Constitution applies just because he's physically in Iowa? And they say, the statute. What? They can even agree that the statute is not proof that the Constitution applies, that the Constitution is proof of the statute. And then they'll still turn around and accuse me of not accepting their answer. No, because I'm not an idiot, according to popular, some belief, So that's what I would suggest doing. Call them out on it. How
All right.
when they cite a court opinion when you're asking for evidence, say, excuse me, are you conflating stare decisis with res judicata? I thought all cases were fact specific. Well, they are. Well, then why are you keep the burden on them? Why are you citing a court opinion when I'm asking you for evidence? Remember, what you're doing is a cross-examination, so you want to keep that in mind. You're asking leading questions to these people, so put the answer in the question, so that they can just have a yes or no. Okay? That's why it's a lot more effective to do it that way. You should always be thinking in your mind when you're questioning your friends and these highly educated people. Always keep in your mind you're doing a cross-examination. Treat it like they're on the stand. And just keep plugging away with the questions. Bring out their contradictions, but do that through a question, not an affirmative statement, because then they'll just hammer away at you for being argumentative. Have them call the show.
The worst case scenario is they just go through with it. That's the other black box. They just say, okay, we're going to hold you in contempt of court, or if you utter another. I've heard phrases like judges mention that, like what happened in Oregon. And they just go through it.
Well, yeah, but then you have an opportunity still to put the police officer on the stand, because the police officer is the one who's making these accusations against you. I don't care what anyone says. They can sit there and wordsmith all friggin' day long. I don't care. The fact is, when that police officer is on the street and he wrote you a ticket that you violated the law, he's making a legal determination. If I did the same thing, okay, and I applied the law to certain facts and accused somebody of, I could go and be prosecuted for practicing law without a license. They are giving legal determinations. I'm not saying they're making judicial opinions, but they're making legal opinions. And to those few critics who think that only judges get to make opinions, what the hell do you call an attorney general opinion? It's remarkably stupid in its breadth. It is just so that when someone like you, where they have run over you, and they know the PR says, damn it, we've got to give this guy the opportunity to at least ask some questions of the cop. Well, we'll never survive appeal. It's got to look good. So that when you get there on cross-examination and you start asking these same questions, then they go ballistic. They declare the witness incompetent, end your cross-examination, and unfortunately, in some situations, Brad, when you're talking about where they just run over you, you're going to have to appeal it. But look at the issue you have for appeal. You have the judge declaring the police officer incompetent to give legal conclusions. And yet, his conclusion that you violated the law somehow has to stay on the record. That's just not fair. And anybody who argues that just because the cop is declared incompetent to give legal opinions doesn't mean that he can't testify that you violated the law. That's just stupid. Stupid.
Yeah.
Have your friends call.
Mark, I got to get back to work.
Okay, have your friends call into the show.
Yeah, I'll try and convince him.
Oh, good luck with that. Hey, appreciate the call. That was some good material. And let me know. Hey, good luck. Get to doing the role playing, and let me know how it turns out.
I will do.
All right, appreciate the call. Brad in Austin, Texas. And now we'll go. All of a sudden, I went and I looked at the call line. I was like, damn, it's like a Saturday. Well, again, 2 weeks ago we had a lot, but. Is this Anon? Area code 864. You're live on the No Stay Project. What's your name? Where are you calling from?
Hello, Mark. John here from South Carolina.
John from South Carolina. What do you got for us today?
All right. You got some information here. If it can be of any help, just kind of direct me what you want to hear. But I was in Baltimore, Maryland, and received a parking ticket. And I was on good ground because it was not accurate what they charged me with. And I had a little bit of pre-trial date interactions with the court. And then I went up last week, December 7th, and I had my court date, and I have a transcript of that hearing. It was only about 2 minutes and 18 seconds.
Wow.
Yeah, and whatever you want to do, though. I mean, the pre-trial date. I sent a request. I called the clerk of court and asked that I'd like to have pre-trial discovery. And they said, well, just write up a letter and send it up here, and a duty judge will review it. And I said, write a letter? What do you mean? Yeah, well, just write a letter. So I just wrote a letter and sent it up. And I requested pre-trial discovery, that the prosecution would divulge all evidence. And I requested also that the presence of the officer would be mandated at the hearing. And lo and behold, a duty judge granted my request. Now, in Maryland, rules of court don't allow for pretrial discovery at district court level. But, hey, I had a judge's signature, so I immediately that night crafted up a letter, sent it to the city of Baltimore, and said, in accordance to this court-granted request, send me all your evidence and a list of any potential witnesses. And I sent a copy of that letter to the court for filing, and I guess somebody must have hit their heads, and they realized what they had done. And about a week later, I get a note back where they took this court order that they had granted and scribbled all over it, and scribbled out the date and the judge's signature and everything, and put on there only the presence of the officer granted, all other requests denied. But it was too late. I had already sent to the city of Baltimore, and then a couple of days after that, I got the discovery information from Baltimore, and it had 4 pictures, all dated at about this occurred in July 19th, all timed at around 12:47 through 12:49, which were 3 pictures of my automobile, my van, and 1 picture of the posting sign, no parking without a permit. Are you following with me okay?
It's a lot, yeah, but yeah, I've got it, and it's remarkable that... Well, anyway, we'll finish.
Okay, and so I submitted the motion the day I went up early, and I sat in on the morning session. I had an afternoon session, and I tried to get how this judge handled things, so I'd feel a little more comfortable. And I guess at that level of district court in Maryland, they really don't care about rules of court whatsoever.
Do you think the Maryland court is somehow different than other courts that do traffic?
Yeah, absolutely. Yeah.
Wow.
And this guy, I will say this now, and don't think that I'm flipping on you here or I'm a troll. This is not true. He dispensed with any regard for rights or court procedure or anything like that. But his actual judgments within the context of the statute and what the people told him, I actually believe in that regard, in that limited regard, he was very fair. If the judge or if the policeman couldn't put up information or got clouded or it was a key issue, he dismissed. Boom. That would be it. He'd toss it real quick.
Okay. Well, did you file the motion to dismiss that I have available?
No, I'm sorry, and I'm telling you this for constructive purposes. I'm so dumb, I can't get around on your site good enough to get a hold. I tried, and likewise, my computer will not take Skype, and I wanted desperately to get into role playing, but it will not. I can't get Skype to work on my computer, so I'm sorry, I'm out of fingertips, and it's my failure and my equipment problem. I'm sorry about that. But I listened to you enough to pick up fragments of what it said, and with what good common sense I could try to use and other references, I tried to craft a motion to dismiss somewhat accordingly, but it was not exclusively on evidence to show that the laws in the Constitution of Maryland applied.
Okay. Well,
They did not have
what was some of the other issues?
Pardon me?
Give me an example of one of the other issues that you raised in this.
Well, it requires in this Constitution of Maryland that all courts have a seal, and that all paperwork issuing from that court must have the authentication of that seal, which none of them did. It requires all paperwork coming out of the courts must be captioned and titled, which none of it was. There was no case number ever assigned. They just kept referring to my citation number.
Oh, that's fine. You're dealing, but this is a parking ticket, so that's probably just the way that they do it. And
okay.
Yeah. So
no defendant or plaintiff was ever listed. Nowhere. Just things like that. I mean, just multiple breaches of, I just say, normal jurisprudence. So, yeah. So anyhow, that's that. But if you want to hear the 2 minutes and 18 seconds of a live court session, just last Wednesday, I have that available as well.
You're going to try to stream that now?
I can run it through the phone, I believe. I hope so. If you want me to.
We'll give it a shot. It's only 2 minutes long, so if it's really bad, then I'll have to mute it.
Okay. All right. Fair enough. Now, all I did is I ran a few seconds, so he just called my name. The judge has called my name, and I just got it past there. He said, for example, is John Smith here? Is John Smith here? And I said, yes, sir, and that's right where the tape picks up.
Okay.
All right. Ready to go?
Run it.
Thank you.
The courtroom. Is that you, sir? Can you stand right behind this microphone? Right behind the microphone. Mr. Schultz, it appears you have 2 citations. No, I take it back. There's only one. There's something unusual about this, too, but I'm not quite sure what it is. Did you make a demand for the presence of the officer?
On September 3rd, through site certified mail, it was granted by the judge, yes, sir.
Okay, I believe you. So was this postponed once before? I'm not too sure what happened.
For that request.
So it was in once before.
For, I think,
and the officer wasn't here?
No, sir.
And it was postponed for the officer to be subpoenaed? Is that the point?
Before the trial date occurred, I sent in certified, and Judy Judge gave it, his request to his policy presence, and that was set for today.
So there's a subpoena, but I don't know where it came from. I'm not sure what the judge just, you didn't fill this out, did you? I mean, it is possible for civilians or non-court personnel to do this. This is issued 27 October. In the same case, 975-04519 for Officer Logan. So I assume it's for the. So this is on the afternoon docket. It's for 2 o'clock, December 7th, which is today. So to conclude, you asked for the parking control agent to be present. You're here. The parking control agent is not present, and therefore your case is dismissed.
I just want to say, one record that was for a third. I drove from South Carolina to be here for this.
I have no idea how this happens.
As a matter of
I can extend you to my sympathy for the inconvenience. I'm not the maker of this. If you wait for the rest to hear me say that, well, I'm going to tell the rest of these folks who are here for the first time.
this transcript will be available.
We're going to hand it to you before you leave.
The transcript, all of the
For the transcript, you'd have to request.
Yes, sir.
Sure, it's a matter of public record.
That will be available.
It's a public record.
Thank you, sir.
You're welcome.
Thank you.
Sorry for the inconvenience.
Yes, sir. Have a good day.
You do the same thing.
That was it.
Well, it's great that the police officer didn't show up.
But here again, he never took a plea. Yet on the paperwork he gave me, it said I made a plea of not guilty. And I guarantee you, all it was missing a few seconds when he called my name twice, and I said here, and that's all I deleted out of this, that whole audio.
Yeah, well, what they like
So
to
he
do.
never-
What they like to do, John, is when you file a motion to dismiss, they like to take that as a plea and a request for a hearing. They do that here in Arizona, which is a real we construed your motion as a plea of not guilty. I'm like, Can I just construe this to be completely lacking in merit and walk away without any problems? Well, that's great. I'm glad that
whatever comments or whatever you can ask me or want, that's great. But I just wanted to say, like Mark, I really admire your work. I admire what you do. I try and suck up everything I can. Like I say, because I'm not that techie, I can't make maybe full use of all of it. But I thank you for your labor and what you do in this field. I admire it. Thank you so much.
Well, I appreciate that. And just to point out, this had very little, if anything, to do with me, because you didn't get the motion and you kind of did your own thing, and then the cop didn't show up. It's great that you stood toe to toe with them and you challenged them. It's great that the cop, because most of the time that we do this, the cop doesn't show up, which the critics like to use to say, even when we have the motion to dismiss and we've gone through arraignment and pretrial and whatnot, they'd like to say that it still had nothing to do with that. But here, that's pretty much the case, but still, congratulations. You took a principled stand, and I don't know what's going on with the Skype. I have my own tech issues here on the show, which is legendary at this point. Why it won't work on the phone, I have no idea. I don't have a cell phone. Find somebody else's computer if you have to. Maybe update your operating system like I have to do. Maybe that'll help. But without getting into some of the particulars, I have nothing.
Right.
I got nothing.
Yeah, I followed you. I followed you for quite a while. I picked up on you probably not terribly long after Adventures in Legal Land was put out.
Wow.
And from time to time, I'd refer to you and check things out. And at least when I saw it on online, and it actually gave me the inspiration and the line of thinking and a mindset that 2 or 3 years ago I stopped in Pennsylvania. And I did that there. That time I slapped through a stop sign inadvertently. It was a change of pattern in my hometown, and I got in my automobile 10:30 at night. I was tired. Didn't even think. I went right through what used to be an intersection, no stop sign, but it was there, and I didn't see it. My error. I did it. But there was a state policeman sitting there. I saw his lights and grill and push bar and everything. I thought, oh, state police there, be careful going out of town. It's 35 till I get out of town. Well, he lit me up. It ended up he went about crazy on me in a nice way, but accused me of having materials for making meth, maybe, and he ended up calling in other police. And I was polite to him. I gave him my paperwork. I had everything, and he detained me for a good hour or more. And I kept asking him, am I under arrest? Have I done something illegal? Yeah, he went through a stop sign. Outside of that, did I do anything? Do you see anything illegal? Have I done something? Well, it depends. And then, so I asked my son to come. I quick phoned my son and said, come up and be a witness. And he stood on a public sidewalk and started videoing him at a reasonable distance. They were over on him. Give us your identification. They cuffed him and threw him in the back of their car so quick he could have blinked an eye. And on and on and on. So anyhow, I, with your information, some of your basic thoughts and the methodology, I did successfully defend that stop sign charge in court. The cop was unable to sustain his stop sign citation, even though he sat there and saw me go through the stop sign.
Well, I'm glad that I'm glad, and because they thought that you were making meth, I shall now call you Jesse, and I will tell you, that from now on, if you do get stopped, don't talk.
Yeah.
Keep your mouth shut. When they ask you something, I don't answer questions, and say, look, I'm not answering any of your questions. End of discussion, and just stand mute for the rest of the time. Could they make something up? Yeah.
In this situation, if you can kind of feel my situation, I was alone, and I was 600 miles from home almost.
Okay.
It was late at night.
Yeah.
I had no witnesses there, and I heard the policeman behind the van saying, we're going to take him into custody and impound the van.
Okay.
And I'm like, holy crap. That was something I really didn't want to get into that moment. And I was clean otherwise. I mean, I didn't have a joint on me. There was nothing. I was clean. Well, I did have a couple guns in the back of the car, but they were encased and behind the passenger's side and empty and all that. But otherwise, I was clean as a whistle. And, I maintained my cool, but I was very short with my answers, but I did continue to answer. And I can appreciate you saying don't answer, and I normally would have. If I would have been local, I probably wouldn't have answered. But I think that time a cool head and keep just staying with it actually helped me from deeper trouble. Maybe I'm wrong, but
maybe. Well, you were there.
They were back behind, actually saying we're going to impound the vehicle and take him into custody. I was like, oh crap.
Well, you were there. It may very well have helped, but generally it doesn't, and
Right.
it's usually just not a good idea.
I hear you.
I've got some other callers,
Yep.
but I do appreciate the call. And
Mark,
congrats.
thank
Thanks for
you so
taking.
much.
Thanks for taking a principled stand against those people. Yes, the cop didn't show up, but you did stand on principle, and that's always valuable. So thanks again for the call.
Yep.
Always cool when somebody stands up to the vermin, to these criminals. And I say that they're criminals because I have the evidence to prove it. If you force a stranger or strangers to give you money, you are a criminal. It doesn't matter if Zeus, if you're acting from, on high, criminal, not honorable. Unless by honorable, you mean criminal. Criminal. Always good. Unless there's certain, specific circumstances surrounding what's going on, it's always much better, I think, to take a principled stand against these people. Make it the most difficult fine they've ever imposed in their life when they go to their favorite watering hole, whatever the hell it happens to be. You want them to be going on about it for months, years later. That they'll say, I can't believe what he did to me. Don't make it easy for these people. They're criminals. They don't deserve it. We have area code 602. What's your name and where in Arizona? Well, I guess the Phoenix Valley are you calling from?
What's going on, Mark? I'm Mark with the K. I'm out here in the Mesa Gilbert border. How you doing?
You're in the Mesa Gilbert border?
Well, yeah, I'm in the baseline.
Oh, gee. I'm actually the fortified compound is
And
like
you're right around the corner from me. I know it. How you doing?
you. Well, you're saying metaphor, not that you. Yeah, but well, I'm doing well.
Stapling and baseline.
What was it? What in baseline?
Stapling and baseline.
Oh, stapling baseline. I'm further east, but I'm in that little piece of Mesa that was sandwiched in the middle of Gilbert a while back. So I'm off of 202.
Arrested for disorderly conduct, resisting arrest with aggravated assaults, and not giving true name. Went to court. They have court, as you know, in 4th Avenue inside the jail. There was no prosecutors there. There was no defense attorneys there. And basically they called my name, and I got up there, and I says, state your name, which I did. And I says, where's the plaintiff? I asked him, is this criminal or is this civil? And he says, well, it's criminal. I says, okay, well, then where's the plaintiff? And, of course, they do their hawk and jaw, like, blah, 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 we don't need. I'm like, well, where's the plaintiff? Because in order for this to be a criminal offense, there has to be a plaintiff. And I see no plaintiff here, so I challenge the jurisdiction of the court. So he says, well, I'm going to assign you a public defender. And, of course, I objected. He's like, no, you can't do that. And he says, I'm going to give you a public defender. I objected over 3 times. And then I went on to say, look, I'm invoking my right on the Arizona Rules Criminal Procedure 6.1. And I've already went through this and have gone without an attorney for 19 months for an aggravated assault on a lieutenant in the Mesa Police Department's Internal Affairs Division. Now, I went through this for 19 months, went through about 11 judges, about 8 prosecutors.
11 judges?
Myself. Oh yeah, I have it all. I have transcripts from 404B hearings. I have the all. Later on, you can call me back. I'll give you my case name. It's all on public record. But I did use what you have been doing. Challenge jurisdiction and prove jurisdiction, subject matter, personnel, motion to dismiss, failure to state a cause of action, total of evidence. I did all that, and I went through my whole trial. And the judge would not let me testify based on what happened, based on transcripts that happened 30 days prior to my trial with the 2 officers who had made the complaint.
Okay, well, we've got a couple of things to get through. Hold that thought. When you were first in front of the judge, why didn't you do things the way I would do them? Why are you making affirmative statements instead of just asking questions, such as where is the prosecutor's evidence to prove that there's territorial and personam jurisdiction over you?
Well, I just asked where the plaintiff is, period, because there was no plaintiff.
Yeah, but isn't it? I think it's much, much better. And because from what you were relaying to me is you were saying this is criminal, it has to be a plaintiff. Obviously, actually, you say, look, it's an adversarial proceeding, right? Well, where's my adversary? And an easy thing is that this is an initial appearance. It's not necessary for them to be there. However, the prosecutor does need to be there to provide evidence that the court has jurisdiction to do what they're doing. So for you and those listening, I hammer away at this. There's a reason for it. We're always putting the prosecutor's burden, front and foremost. Has the prosecution presented sufficient facts to prove that the Constitution applies to me just because I'm physically in Mesa? Yes or no? Where's the proof? Okay, so 19 months, what did your discovery look like? What did your Brady request look like? Did you get it from me, or what did you do?
Well, yeah. Well, to make a long story short, that was a 19th month endeavor. This just happened recently, what I'm talking about now. That case before, this happened a couple of years ago, which is where I learned from you. Even though the jury found me guilty, the judge suspended my sentence and didn't sentence me to prison, didn't sentence me to doing time, and I basically it's because I believe I never let them gain jurisdiction over me. I never allowed them to assign an attorney to me, and I never made a pleading of guilty or not guilty. Out of 19 months, I never made a pleading at all.
Well, what's going on now? I mean, what's this where they're saying that the judge wouldn't let you testify? Why would you testify?
So now I went to court, and, he's like, well, you need to have an attorney, and I objected. And so they released me to pretrial services. I get out. They gave me 2 court dates. One was Halloween, and one was November 4th for prelim. I went to court on Halloween, and before I went to court on Halloween, I had filed a motion. In the motion, it says that defendant invoking presumption of innocence comes before the court under duress to rebut the presumption of the plaintiff. Defendant waives his right to counsel after review of ARCP 6.1, invoking ARCP 6.1c, moves this court for an order of dismissal under ARCP 16.6 for lack of jurisdiction under ARCP 16.1 and failure to state a cause of action. And then in the memorandum of the motion, I put as anticipated that a deputy county attorney from the Maricopa County Attorney's Office seeks to be a plaintiff in case number such and such. Or incident number, and I referred to the police report. And the reason I did that is because when I went to the city of Mesa to the police department to make a records request, paid my $5, it says there was none. There was no complaint, and there was no police report. I'm like, well, how can that be if I have court dates and I've been arrested and I just got out of jail? So they, claimed that they didn't have any. So this is why I worded it the way I did. So I put that records request to Mesa, Arizona Police Department, and that someone has made a judicial determination that I am a criminal defendant in said case, absent of evidence in jurisdiction. and an invalid direct complaint was filed on October 18th, 2016. Complaint and information is insufficient as a matter of law. No factual allegations in the body of complaint, which is ARCP 16.6, and Maricopa County's attorney's attempts to gain jurisdiction or attempting of eliciting some type of helpful testimony or opinions or conclusions from a defendant constitutes a tour of investigation and willful anticipation that helpful evidence will appear. Is not permitted under Rule 15, causing abuse of process. And of course, I quoted another thing: abuse of process can arise from civil and criminal proceedings, Lamantia versus Redici.
Okay, well, so before we're out of time, because I have other callers I'd like to get to before the hour is up, get to the heart. I mean, so where are we now with this? I mean,
so when I went to court on Halloween, I went there, I gave them the copy of the motion that I filed that was recorded with the clerk of the court, and they said, okay, you need to sign this waiver of counsel. So in the waiver of counsel, it's like 300 different words. I crossed out 5 words, which basically was consenting to the charges, consenting to be sent to prison, and consenting to all this crap. And I handed it back to him. Well, of course, the judge says, I do not accept this. You need to go back to the public defender's office. I says, I will. Then I went back to public defender's office.
Wait, hold on. Why wasn't there any discussion and an objection that you're not signing anything that says that you're consenting?
They just said I need to go back. That's what I told them. I said, I'm not going to, why would I sign this? I says, first of all, I don't have an attorney. So how can I waive an attorney if I don't have an attorney? I've never requested an attorney, and I've objected to an attorney in my one and only court appearance where there was no plaintiff, where there was no evidence of jurisdiction, where there was nothing.
Okay, so you're going to do some role-playing and do some better objections with these people, especially if this is still going to go to trial, which it looks like it probably is. So where does it sit right now?
So where it's sitting right now is when I went back to the public defender's office to say, do I have an attorney appointed to me? And they said, no.
Okay.
I said, are you sure? They said, positive. I said, when's my next court date? They said, my next court date is November 4th. So lo and behold, what they did is that was at 9:30 in the morning. That same day at 3 o'clock in the afternoon, they had a public defender come in without filing a notice of appearance, claiming that he was representing me, and guess what? I didn't show up for court, which, of course, I was never told to show up for court. So now there's a warrant for failure to appear, which obviously I didn't filter. I actually have the minute entries where I was in court having a discussion with them. So like you said, they're just liars. A lot of people need to understand is they can't comprehend the fact that someone could continuously lie right to their face. And that's why a lot of these people get intimidated. I've already won 3 trials. I won trial in Florida, Alabama, California. And the reason why I'm doing it this way is I want to show people that exactly what you're doing, what you're saying is true, and that it's all about psychology, and it's all about manipulation.
Yeah, but do the role playing do the role playing so that you're applying the Socratic method better instead of making affirmative statements. So stick to the whole thing. Really revolves around whether we're talking to the judge or the prosecutor or the police officer on cross-examination. It all hinges on their foundational claim. You're in Mesa, the rules apply, and that's why we hit that so hard. That sets the relevance for everything else. So make sure you do some role playing. There's a link on for the Skype chat at markstevens.net under upcoming events. And you can also always contact me at Mark Stevens, at Frank Rizzle 3 on Skype, and I can put you in. And make sure you do that. What sucks here is that you need to file a motion to quash the warrant, but you don't want to have to show up and be arrested. So
right.
the process.
Well, let me get off the air so you can get some of the callers.
Okay, well, keep in mind that, you want a motion to quash the warrant, but the public defender probably won't want to file a motion that I have written or that you've put together. So
I don't have a public defender.
Oh, well, good. Well, then, all right, we'll get your motion. motion to quash the warrant, and I would get it done. I would put in to have it done, a hearing held telephonically, so that you don't have to risk being arrested in order to have the issues heard.
Exactly, because I've already went through this before where I've done this, and they arrested me on the spot, and then I bailed out, and then gone back to court, continued with the same argument that you project, and they tried to declare me crazy, mentally incompetent. And that's where actually a public defender actually did step in, who wasn't representing me, and represented me for 1 10-minute period, and says he knows the date, the year, the president, he's competent to stand trial. But that's what they do. So once you start arguing with them and you're getting the better of them, they just declare you incompetent.
Well, they can. It's not nearly as common, though. It's still very, very rare that they do things like that with all the people.
When's the last time you've been in jail, Mark?
The last time I've been in jail?
Yeah, right here, Phoenix.
I was in the Mesa, the Robson station, back in 2000.
Okay, so it's been. Listen, I've been arrested 58 times. You're speaking from a point of view. You have to go to jail unless you've been in jail and not listening to people talk to you, and not looking at the. Unless you're actually sitting in jail and sitting in court and watching what's happening on. It's going on a lot more than you think. A lot more than you think.
Okay, well, let me. As far as the way we do things here,
first-hand knowledge perspective.
I understand. I'm still based on my experience and all the people that I'm working with. So let's just look at and using my method, or the Socratic method, to challenge these things. In that scope of okay, with all the people that report back to me and call the show, very, very few of us have been threatened with that. I would say it's less than 1 in 200. So it may happen to people outside that are not doing things the way that we do it, and it could be for various reasons. It's unfortunate that they are using that as a tool more, and you're seeing that. Hopefully it's not always the case when people are fighting and challenging the prosecution's evidence the way we do it.
Right. All right, well, I'll get a hold of you. No.
Yeah, you can contact me off air, but you definitely want to get in a motion to quash the warrant on it and request a telephonic hearing.
Sounds good.
All right, appreciate the call, Mark, right here in Mesa, Arizona. Yeah, that's the thing. The last time I was in jail was the Robson station, I think in 2001. So I had a flurry of arrests where I was arrested 9 or 10 times. I did not go to jail each time, and as far as jail, it was, yeah, I've been to the Madison Street dungeon a few times. That's bad. We've got another call before we're out of time. We got Jose from New Jersey. How you doing today, Jose?
Hey, what's up, Mark? I'm good. How you doing?
I'm doing well. How you?
What's you call it? I'm good. Which I had court on Monday, right?
Okay.
And they arrested me for not standing for the judge.
Oh, jeez.
So I didn't even get to have a trial.
How long did you have to? Oh my gosh.
Yeah.
You were held in contempt for that?
It's funny because, yeah. They were like contempt of court. I was like, I have to be warned like 3 times before that, right? And he was like, and the cops were like, oh no, I am the law. I was like, fuck out of here, you're not the law, man. You're supposed to uphold that shit. You over here fucking arresting me for no reason. Like, come on.
Did he actually quote the movie Judge Dredd, I Am the Law?
Yeah. He said that, He said that on multiple occasions. He was saying because when I first had court, he kicked me out because I didn't stand for the judge. So now I didn't stand for the judge again, and then he just arrested me.
Okay, well, let's break this down. Is it the cop saying this, or is it the judge saying it?
No, the judge. He was a new judge. I never seen the judge. He was chilling. You know what I'm saying? He was like, all rise, I ain't rise. And then he said, all, like, sit down, and I was still chilling. And the cop is just the cop, like, he was just wilding. And then he just arrested me.
I'm sorry to hear that. Jeez.
So now I gotta...
How long did you stay in?
I'm chilling. I was in there for like 5 hours.
Jeez.
Process and everything. So now I got a new court date with a new fucking charge for contempt of court.
That'll probably be thrown out. That's ridiculous.
Word.
Holy crap! That is just.
Yeah.
Note to self:
wondering,
stay the hell out of New Jersey.
Can I get a counterclaim against him or something?
Counterclaims don't work in in criminal proceedings. Counterclaims are only in civil. And the rules in traffic and whatnot don't even allow for something like that. What I would do is I would file a claim against the municipality's insurance for the false imprisonment.
Right.
I mean, the not standing is ridiculous. Even in California, they've
like,
never.
Come on. Yeah.
So they edit.
So,
wow.
Then I gotta. What?
I'm just floored. I mean, what a scumbag. I mean, seriously, what a scumbag.
Yeah.
You imagine trying to pass a law that it was criminal not to stand when a politician walked in a room? They'd be laughed out of their own.
Right.
They'd be laughed out of their own, building. But
the whole time, I was like, "What law? What law?" He was like, "Oh, there's court rules." I was like, "What rules?" He's like, "Oh, this is our court." I was like, "Bro, this is the people's court. Fuck out of here."
Oh man, there's no well, let's watch the language, but there's no damn rule that says you have to stand up. That'll probably get tossed out, so I wouldn't worry too much. But I would still file a claim against their insurance for the false imprisonment. So, what's going on with the underlying charge, though? I mean, did they reset it for another trial date?
I guess they set it for the same date because I asked the cops. He was like, "Oh, it's just you got a new date. That's it." So I guess the day I have to go for the contempt, I'll go for the other charge.
What day is that?
But I sent in the 11th of January, and I sent in the request for reconsideration. Haven't heard back from that either. I haven't got anything for the Brady request, so I don't know if I get that in the mail or I get that in court. But I haven't gotten anything.
You should get it in the mail. I would call the prosecutor's office tomorrow and find out where the hell my Brady material is.
Yeah. Okay.
Okay. If they lie to you.